was just a laborer in Johannesburg. Actually, he would sometimes be away from home for 2 years, 3 years without him coming back. So that's how much absent he was in our lives.
How easy or difficult was it to become a university student in terms of resources?
It was very difficult, Chief Justice. You know, when I had to go to boarding school, well, I lost a year at one stage because the school in the area where we lived went only up to standard 4. So if you wanted to study further, you had to go to a faraway place and live with relatives and then study. So one time in 1 year, I think it was 1973, my mother sent me to a relative in another place in High Flats, and I started schooling in the school in that area. But she had only spoken to the mother of the house. The father had not been there. So when the father came, he kicked me out. I had to go back, and then I spent a whole year without schooling. And then only the following year could I continue. When I went to boarding school, my mother had to buy second-hand pens from the owner of a shop. The pens belonged, for example, to this shop owner's son. It was a white family, and she was working for them as a shop assistant. She didn't have enough money to buy new pens for me, so she bought second-hand pens from the family. And I went to boarding school. When I went to boarding school, I had one gray pair of trousers and one khaki pair of trousers only. But when I was at boarding school, I was lucky that the principal of the boarding school, it was a Roman Catholic school, I think identified me as somebody that was deserving of assistance. He approached me and asked me about my family circumstances, and I think he could tell that I didn't come from a well-to-do family. And he gave me a bursary address and asked me to apply. I applied. It was I think it was under the Roman Catholic Diocese Bishops' Conference, I think it was. And that took me up to matric. And after matric, I also got another one that took me to university for my junior degree.
I have somehow learned that there is a particular loan relating to food that you took.
Yeah.
And I raise these things because many people in South Africa are poor, and they could be inspired not to lose hope no matter their circumstances if they were to hear your story, considering the position that you have been nominated for. Tell us about that loan.
Thank you, Chief Justice. When I finished matric, I was quite confident that I would get what used to be called then exemption, and therefore would qualify to go into university. I didn't think I would have a problem with getting that. And I was confident that I was going to get a bursary too. But my problem was that at home, the situation was quite bad. My mother had stopped working 2 years before my matric. She had lost her job. And by the time I finished what would now be called grade 11, she said she had exhausted all her savings. And so somehow I felt that the society, the community would be thinking that after matric I would now be able to go and work and help my mother, whom the whole community could see was struggling. But I wanted to go and do law, and I was determined, but I felt that I couldn't go unless I made arrangements to make sure that my mother and my brothers and sisters behind would be able to have something to eat. And my mother was not working, she was knitting and selling jerseys, but that wasn't going well. So I decided one Saturday to go to Ikopo, to town, and I approached a certain Indian businessman who owned a certain wholesale shop. I told him my story, said I wanted to go to university and study, but this is the problem. Is there any way he could give me a loan, which I would use to support my mother and my siblings, so that after I'd finished my degree, I could then pay him back. Very interestingly, that man didn't even ask me many questions. He said, okay, I can help you, but I can't give you money. I'll give you a voucher, which you must give to your mom. Once a month, she must come to my shop, and she will be given groceries up to the value, I think it was 20 rand, if I'm not mistaken, 20 rand or 40 rand, but that was
A lot
long
of
time
money
ago.
back then.
Yeah, it was quite some money then. And he said, until you finish your degree, this is what we'll do, and then you can repay it after your degree. So I was very happy. He didn't ask me to sign anything. He just took my word. And my mom could not believe it when I came back from town and told her that I had been able to make arrangements so that they would be able to have groceries while I was studying. And that is what happened for 3 years. And when I'd finished my junior degree, I went back to this man. His name was Mr. Musa, and thanked him and asked him what arrangements we could make for me to pay back. Sorry, Chief Justice. So he said, no, don't worry. Just do to others what I've done to you. And I thought that was very important. And in my own small way, I tried to do that.
Until now.
Yes, Chief Justice.
Now, you hold a B.Juris degree from the University of Zululand
Yes,
and a Bachelor of Laws degree from Natal.
yes.
There was a gap, isn't it? After completing in '83, you didn't immediately proceed to do LLB.
Yes, Chief Justice. What happened was that the bursary that had been paying for me when I was doing my junior degree indicated that that's how far it could go, and therefore I had to find other sources, and I wasn't able to immediately find other sources, so I looked for a job. I got a job with the Legal Resources Center, and I worked there for a year. And then, during that year, I wrote to the then mayor of Durban and put my situation and said I wanted to go and do LLB. And I wondered whether there could be any scholarship. And she arranged, I think she was called Mrs. Scotts. She subsequently wrote to me and said she had spoken to the Sunday Tribune because they had a certain scholarship and I should be in touch with them. And then the Sunday Tribune provided me with a scholarship to do my LLB degree. which I then did the following year, the following 2 years, Chief Justice.
And at some stage, we were with the Mqenge firm. When was that? What were you doing briefly?
I was with the Mqenge family, I think 1985 to sometime in 1986. I was doing articles at that time. And after that, I went to, after Ms. Mqenge had been assassinated, I went to another law firm, I think Tembu and Company, and after that I went to Channels Albert in another law firm.
Yes. And this is very strange. You hold 3 Master of Laws degrees.
Yes, Chief Justice.
And I understand that when you, in 2005 you graduated, 2 were conferred on you at the same time. Is that correct, or were we misled? Remember at some heads of courts meeting, Judge President Mwepe, who was the Chancellor of UNISA at the time, said, I conferred 2 degrees on this man. I don't want to embarrass him. 1 cum laude. Is that in fact so?
Yes, no, it is so, Chief Justice. 2 were conferred on the same day. And what had happened in regard to that is that initially I had registered for an LLM, which was going to be coursework plus a mini dissertation. But after some time, I thought that the mini dissertation I could do as a full dissertation for an independent LLM. So after some time, I then arranged with university that I should do the dissertation as a full dissertation, and that instead of the mini dissertation, I should do another course, another paper. I should add another paper.
Yes.
And I think one of them maybe I did for 3 years, the other one maybe 2 years. I can't remember.
Very well. And this one with specialization in commercial law, what specific courses were you taking there? Just very briefly.
Yes. I think one of the causes was the law of trademarks. I think another one was competition law. I think another one was constitutional interpretation. I think there was another one.
Yes.
Yeah.
And the third one was on patent law.
The third one was on patent law.
Now, you have been a judge for 20 years now.
Yes, Chief Justice.
And judge president for a little under 11 years
That is
of
so,
the Labor
Chief
Court and the Labor Appeal Court.
Justice. That is so, Chief Justice.
I noticed that you have also, well, you have also been the chair. You are the first chairperson of the governing body of the CCMA.
That is correct.
Any leadership experience from there, to write home about?
Well, I think, Chief Justice, I gained quite some experience there. This was at a time when the CCMA had just been established, and there was a governing body which, on which sat representatives of organized labor and representatives of government and organized business. And to be chairperson, you had to, all of them had to agree upon you. They had to enjoy your confidence. I was honored to have been asked to be chairman, and since it was a new organization, there was a lot of work that needed to be done in terms of planning. You know, this new organization, we had to say, how is it going to operate, and what policies should it have? And I remember one time we went to, I think, Cape Town, and spent a whole weekend on strategic planning. At a strategic planning workshop. So definitely I gained some experience there.
Yes. And as Judge President, you were part of a body known as the Heads of Courts, which provide, under the chairpersonship of the Chief Justice, that provides leadership for the entire judiciary.
Yes, that is so, Chief Justice.
And I know because I was part of the committee, there is that committee that was established to look into issues of race and gender discrimination within the judiciary, chaired by Chief Justice Langa, that you and I were asked by our colleagues to serve in.
Yes, that is true, Chief
And
Justice.
there are recommendations, of course, as to how to deal with those issues.
Yes.
And also, you actually initiated, we responded to your initiative to set up a committee that sought to resolve the sensitive issue between the Constitutional Court judges and Judge President Hlophe.
Well, your memory, Chief Justice, might be better than mine, but I know that I was involved, but I can't remember whether I initiated or not.
You so initiated that the first meeting was held at the Labor Court.
Oh, yes. No, you are right, Chief Justice. Now I remember.
You
Yes,
commissioned
yes,
the Judge President
yes.
Somyalo and I to actually go to the Chief Justice and the Deputy Chief Justice
Yes.
and Judge President Hlophe to try and resolve this issue, so that, because our fear was it may take years
Yes.
before it was resolved, and a lot of damage might be done to the reputation of the judiciary in the process.
Yes. No, now I remember quite well, Chief Justice. That is true. We had that meeting at the Labor Court, and as you say, that was one of the decisions we took.
And presently, you are the chairperson of the committee, comprising Justice Jafta, Justice Kampepe, and I think Justice Mhlantla, that has been charged with the responsibility to organize the Congress of the Conference of African Jurisdictions in Africa.
Yes, that is so, Chief Justice.
The conference that will be taking place from the 23rd to the 26th of this month.
That is so, Chief Justice.
And you have been to represent me when nobody was available at the meetings of the executive bureaus of the CCJA, twice at least.
Yeah, that is so, Chief Justice.
Yes. Now, what contribution, in your own words, what contribution do you hope to make? What role do you hope to play if appointed Deputy Chief Justice in ensuring that courts deliver better than they have been? Just in your own words, very, very briefly. I know that generally you are a man of detail. Your judgments tell. Very briefly, what have you identified as challenges that call for further attention, and what is it that you think should be done over and above what has been done? Where should more emphasis be laid? Just in a nutshell, give us your vision, or even if you are deputy.
Well, Chief Justice, I see the role of Deputy Chief Justice, if I were to be appointed to the position, as the role where the incumbent gives support and assistance to the Chief Justice and shares views with the Chief Justice on various issues relating to the courts and the judiciary. I am aware of various measures that you have put in place, for example, that are meant to address a number of problems and challenges within the judiciary and the functioning of the courts. You have the NEEC, you have the PEEC, and NEEC being the National Efficiency Enhancement Committee, and the PEEC being the provincial equivalent, all of which bring together stakeholders for the purpose of saying where are challenges that affect adversely the functioning of the courts and what should be done about them. Now, I think that I would like to play quite an important role in that regard, because I think that one of the things that the judiciary and the courts must strive to do is to ensure that the service that they give is good service to the public in general. Now, good service in regard to the courts is making sure that essentially judgments are given reasonably, timelessly, that judgments are judgments which people can look at and say, even if I don't agree, but I can see that the judge applied his or her mind to it. I also think that with regard to various cases, it might be important, Chief Justice, that there be a discussion about whether, to the extent that there is some limited role for mediation that is taking place in our courts, whether we shouldn't have, excuse me, a much bigger role for that. In this regard, I think that if we were to have carefully considered mediation in regard to many disputes, that would ensure that the workload that judges end up having to deal with is reduced. I take the example of the CCMA. In regard to labor disputes, the CCMA has got what is called conciliation, which is a form of mediation. And they have carefully trained mediators who have knowledge of the field of labor disputes. They play a very important role in resolving a number of disputes. I think they go into thousands in a year to resolve them. But if that structure wasn't there, all those disputes would be going to the courts, to the labor courts, and we would be having quite a lot of problem. But one needs to be careful, because there may be other dynamics in relation to other disputes which are not the same as labor disputes. So it may be necessary that one would need to look very carefully at what can be done and what types of disputes may be dealt with properly in that regard. I also think that it's important that the case flow management system that you have already put in place, that it be used very effectively. I understand, I've spoken to a number of JPs, I understand that it is working, and there is no need to interfere with something that is working well. I think also, Chief Justice, that with regard to the contribution to jurisprudence, the leadership is in the judiciary. It's important that they should be able to make quite some contribution in terms of jurisprudence. I think I will play that role. But also, I have got quite a lot of experience, as you have said, in regard to heads of courts issues. For about 10 years, 11 years, I was part of the heads of courts. I can play quite an important role in that regard. But also, Chief Justice, No, when I was in the labor appeal court, at some stage, one of the things I was looking at was this, that a lot of matters that take quite long to be finalized are trial matters. And if you look at motion court matters, they seem to take much less before they are finalized. Partly that is because a judge can hear 2, 3, 4 opposed motion matters in one day, whereas if it's a trial, you might be looking, just with one matter, you might be looking at 3 days, 2 days, 3 days. So one of the things that I would like there to be a discussion and maybe a debate with the profession is whether it is not in the public interest, or it would not serve the public interest better if, as a rule, matters were brought to court generally by way of affidavits. The idea with that is that when it's a trial matter, parties and their lawyers tend to withhold evidence until close to the trial. Whereas if you are bringing a matter by way of an affidavit, you are forced to put up your evidence on affidavit so that the other side knows exactly what case they have to meet. And the result is that in no time, everyone knows exactly what evidence there is against them or in favor of a particular outcome. And if they need to reconsider, they might settle the matter because they know that you have got evidence. Whereas with trials, it can take quite some time when somebody doesn't have evidence to support their case, but they just hope that maybe through cross-examination they will win. So it may well be that it's something that we should look at because it could cut down on the delays in the finalization of some matters.
The version of it that we have started applying, and in fact, this past Friday, the heads of courts resolved that, in fact, we didn't resolve. We had a draft that sets out an approach to a number of issues, all intended to ensure that cases are finalized expeditiously, is this: that as part of judicial case management, you always have a judge running pre-trial conferences for both civil and criminal matters, and that in liaison with the parties so that he or she is able to satisfy himself that issues have been concretized and also witnesses that are relevant, identified, also in circumstances where some people would have been charged for, say, 350 counts. You identify key counts, prefer them against the person instead of wasting time with going to have 300 life sentences and 10 terms of imprisonment. What are you doing? Yeah. So if there is proper monitoring and no case is enrolled, unless it is trial ready, then you come to the same objective at the same conclusion, isn't it?
Yeah, no, that is true, Chief Justice.
Yeah. Now, I'm sure you had rounded up.
Well, safe to say, Chief Justice, also, it is necessary to look at what can and should be done in regard to, for example, RAF matters, so that they could be settled much earlier. Yeah. The state ends up paying a lot of money because either the lawyers for the fund, didn't look at the matter properly much earlier and only looked at it closer to the trial. Had they looked at it much earlier properly and applied their minds to what evidence they have got, they might have settled the matter much earlier, probably on an amount that is much lower than the amount that they ultimately do. But also there are other matters where the state really, if it could look at trying to resolve matters much earlier, they can be looked at. So it may be necessary that a number of areas be looked at to say, where can we make sure we change the way things are done so that we make sure that, one, we save on the public money, and two, we make sure that there is effective resolution of disputes much earlier than otherwise we have at the moment.
Digitization or court modernization?
Yes, Chief Justice, you have, or under your leadership, you have appointed one of the judge president to look into the issue of digitization, and I had the opportunity of speaking to the judge president who is chairing the committee that is doing that. I think that that's a very good idea. In terms of that project, what is being looked at is to make sure that the court system, the filing, and the management of cases once they have been filed in court is going to be done to a very large extent electronically. A system will be put, a computer system will be put in place so that as and when a lawyer or a litigant takes a certain step in the litigation route or journey, that system immediately identifies the next step that needs to be done, and it will also enable the head of court to keep an eye and monitor the progress of various files without any difficulty. It's going to also make sure that heads of courts are able to monitor reserved judgments much more easily than has been the case up to now, once it has been put in place. I think that it's a very important project. It will also solve a very big problem in some divisions, or generally, namely the falsification of court orders, which has been, I understand, quite prevalent in certain divisions. I know when I was in the Labor Appeal Court and Labor Court, we did have some cases where people were presented with what appeared to be court orders issued by judges in the Labor Court when actually they were fraudulent. And this will make sure that this will be taken care of. It will also, as I understand the position, Chief Justice, it will also help with this problem of files that get lost or that got stolen in courts, because all the information will now be kept electronically. Yes. And I understand also that a lot of people who need to go to, like lawyers who need to send messengers to court to get various documents, they won't really have to do that because they'll be able to access whatever documents electronically. I think it's going to be quite an important advancement on our legal system, Chief Justice.
Well, for what it is worth, if appointed, some of the things that you would have to help us resolve is what appears to be fraud in relation to the medical negligence claims and settlements and that entered into under questionable circumstances that sometimes colleagues are ready to endorse because they trust practitioners and a number of other cases relating to arrests and detentions. Yes. It's quite some story. But anyway, in terms of your contribution to the development of the jurisprudence, I see that your labor law, labor court, labor appeal court judgments, you've written those published that you have favored us with 105.
I don't know the exact number, but that must be so, Chief Justice.
And the Constitutional Court, 43.
Yes, Chief Justice.
Well, on average,
44 from last week with the latest hand down.
Now, on average, we write 4 judgments and, per year. It looks like yours is much more. Have you worked out the average? And it's important because at some stage it was looking like people thought you delaying finalization unnecessarily.
I haven't worked out the average, Chief Justice, but I think last year I wrote 17 judgments. Out of those 17 judgments, 15 were handed down. The 2 that were not handed down had been completed, but the reason why they were not handed down was that in regard to the one, I was dissenting from a judgment of a colleague in regard to remedy, and after he had read my judgment, he said, no, I think you are right. If you don't mind, can I just take parts of your judgment and incorporate them into my judgment? I said, that's fine. And then he changed the outcome in his judgment, and there was therefore no need for me to proceed with that judgment and have it handed down. The other one was a matter where there was an issue of locus standi, and the position was that if I upheld the point on locus standi, there would be no need to write on the merits. But because I was writing for many colleagues, I decided that I would write a judgment on locus standi and write another judgment on the merits, so that if I was persuaded by my colleagues that I was wrong on locus standi, then there would be a judgment ready on the merits. But what happened was that the majority of colleagues agreed with me on locus standi, and therefore it became unnecessary to hand down the judgment on merits.
Yes.
In the year before, I'm not sure whether I wrote about 8 judgments or thereabout, that is 2015, Chief Justice. But I think I've written usually more than 4.
Yes. And on average, you really are the one judge who writes more judgments than all of us.
I think that would not be wrong, Chief Justice.
Yes, but that has not occasioned unacceptable delays, has it?
No.
Is there room for a colleague at the Constitutional Court in particular to delay longer than is acceptable or excusable?
I think there is no room, Chief Justice.
Why? Anyway, okay.
I think
I'll leave it to anybody to put questions to you. You know, there is a cry for women
Yes.
to assume leadership responsibilities, even within the judiciary. Now, you've been nominated by the president, and obviously you are not a woman.
Yes, Chief Justice.
But I must say I was struck by something coming from the International Women Judges Association. 2 quick paragraphs. They say, referring to you now, say he showed formidable leadership on gender issues. During his tenure, he met the gender transformation challenge. Before that, not a single woman judge had ever acted in the LAC. During his term of office, he appointed various women judges to act both in the Labor Court and the Labor Appeal Court. His early women appointees to the Labor Appeal Court moved to higher courts. Justice Beth Nkabinde became a justice of the Constitutional Court and also acted as acting Chief Justice for a period. Justice Maya went to the Supreme Court of Appeal, where she will hopefully be appointed President of the Supreme Court of Appeal. Justice Chiki acted in the Labor Court whilst being in private practice as an attorney, and was subsequently appointed to the Gauteng Local Division, High Court, and later to the Supreme Court of Appeal. Justice S.V. Kampepe was appointed to the Labor Appeal Court in 2007, and by 2009 had moved on to the Constitutional Court. Justice M. Liu was also appointed to the Labor Appeal Court and acted in the Constitutional Court, and later became Judge President of the Northwest High Court Division. Justice Zondo is sensitive to the challenges facing women in their appointment to the judiciary and has been instrumental in recommending a female colleague for the appointment of Acting Deputy Judge President of the Labour Appeal Court. His consistency in trying to achieve a gender balance in the judiciary has been characterized by leading and being proactive. It is clear that Justice Zondo has the ability to visualize the future needs of our judiciary, but also has the ability to achieve those goals as he has done in relation to race and gender transformation as described. His purpose and mission from his early years as a judge to this day show qualities that will serve him well in his position as Deputy Chief Justice of South Africa. And of course, the judge, the Acting Deputy Judge President they are referring to is Justice Kampepe, isn't it?
Yes, yes, yes.
And they end up saying that they unequivocally recommend you for appointment. Any comment?
Well, Chief Justice, the support from the South African chapter of the International Association of Women Judges was quite humbling to me. I'm grateful, but what they say there in terms of my efforts to try and give women opportunities is factually correct.
Yes. Very well, I think I must leave you to colleagues now to put questions to you. Colleagues? Commissioner Mutimele?
Thank you, CJ. Good morning, Justice.
Good morning, Commissioner.
Like you, I'm also from very humble origin and narrow means.
Yes.
First question, what would you say to many out there who faces challenges which sometimes seems insurmountable? What would you say to them by way of encouragement and advice? And secondly, how would you advise them to use these documents, the Constitution and the freedoms enshrined in here, to better their lot? That's the first question. The second question and the last question.
Yes.
The second question, the preamble of the Constitution starts with the word, "we the people." How do you understand those words, "we the people"? Thank you.
Thank you, Commissioner Mutimele. I think by way of encouragement, I would say to many young people out there who might face the kind of circumstances such as the ones I and many of the commissioners here may have faced growing up, and sometimes maybe even worse than the situations that I faced, would be that education is very important. Education can change your life, can change the life of your family, can change the life of a society, can change the life of a nation. And that it's important that they should not lose hope, and they should knock on doors to get help, because that is what I did when I went on that one Saturday to see Mr. Musa and say, I want to go to university, but there is this problem. I can't go to university if my mother and my siblings are not going to have food on their table. And that they should approach other members of society and talk to them. I wrote to people that I'd never met. I wrote to the mayor of Durban and presented my situation, and the result was a scholarship. It's not just her only. I wrote to some attorney in Durban that I'd never met, that I read about in a book about his life, and I wrote to him, and he gave me some money for some book books at university at a certain stage. So, so one of the things I would say to them is don't just sit there and do nothing and say you are poor, you know, be proactive. But also I would say that they are growing up at a time when South Africa has a constitution that makes various provisions, including provisions for socio-economic rights, and they need to be able to use those provisions in order to better their position. And I know, for example, that there are a number of NGOs which seek to use provisions of the Constitution in order to help various communities, especially poor communities. And the phrase, we the people, understand that to talk about us, South Africans, we the people, and it is a phrase that shows, in my view, the centrality of the people in our Constitution, how central they are, how much we should always remember we are servants of the people. That's very important. Sometimes we forget that. Sometimes we think about positions we occupy and forget that we are servants of the people, and our job is to try and make sure that we help our people.
You know, just there, I don't know if you're sharing this view. I was saying to somebody, South Africans are the Chief Justice of South Africa. They have lent me that authority, that power of theirs. And if I don't serve them, then it's open to them to decide what to do with the responsibility they have charged me with.
Yes.
I was not born with it. My father and my mother did not give it to me. It is theirs to give or to retract. Is you sharing that?
I share that.
That if appointed as Deputy Chief Justice, you ought not to behave as if you made yourself Deputy Chief Justice.
That is spot on, Chief Justice. If I am appointed to the position of Deputy Chief Justice, I will remember, as I have always remembered throughout my career, that I come from communities that are very poor. I grew up from those communities. And that just because at a certain stage I became a lawyer, just because at a certain stage I became a judge, just because at a certain stage I became Judge President of the Labour Appeal Court, just because I became at a certain stage a Justice of the Constitutional Court, doesn't mean that I'm no longer part of those people. I am part of those people, and I should always remember that they are very important. So if I am appointed as Deputy Chief Justice, that will continue to be my attitude, and we have to always make sure that we assist our communities, we assist our people, and we don't behave as if we are gods.
Commissioner Nyambi?
Thank you, CJ. Morning, Judge Zondo.
Morning, Commissioner.
My question will be linked to the one that was asked by Advocate Motimel. I must first indicate that you inspired a lot of us from those humble beginnings. What will you regard as a significant contribution based on your humble beginnings that will stand out, that will share with us, that you have done in keeping with the words that were said to you, go and do to others?
Thank you, Commissioner. Well, I wouldn't want, obviously, to talk about names, but I have, over the years, made sure that There are young people, students, that come from, needy families that where I've contributed in terms of their schooling. Sometimes I would contribute in terms of groceries for the family. It's something that I'm doing even now, and I intend doing throughout my life as long as I earn some income. I will make a contribution to help others, because if there were no people who were prepared to share what they had with me by helping me, whether it was people who donated money to a bursary fund that was used by the Bishops' Conference, or whether it was people like Mr. Musa, I would never have gone beyond primary school, beyond grade 7. I would never have gone there that far. I've gone as far as I have because there have been people who were prepared to assist me. I've done my part in terms of hard work, but there were people who were prepared to assist me, and I must also assist others.
Thank you. I've seen that at some stage you were a chairperson of the language committee, heads of courts. And currently in South Africa, the issue of language is still a very serious problem. So with that experience of chairing such a committee in the past, what might you consider to be the challenges?
Well, I must say, Commissioner, that I think I've lost that debate already because as you might have picked up from the documents, there was a majority view and a minority view in the report that was prepared by that committee. Part of the concern was this. English-speaking South Africans and African-speaking South Africans, under apartheid, they had opportunities of, when they have got cases, of going to court and testifying in a language that the judge or magistrate knew and could use to talk to them. And whereas with regard to Africans, most of the time it had to be either you have to use English or Afrikaans, or there has to be an interpreter. So one of the issues we were concerned about, or some of us in that committee were concerned about, was whether under democracy it should not be possible that, for example, somebody who is in, for example, a township, or who is in a rural area, who has a case in the magistrate's court, for example, where the magistrate is African, the lawyers are African, the prosecutor is African, whether it would not be possible to have a situation where they could have the proceedings conducted with everybody speaking an African language, whether it is Sesotho, Setswana, isiZulu, or isiXhosa, so that they could just experience this justice in their own language as well. But there are certain problems that we identified in regard to that. And I think that is why, in the end, the position that I think the heads of courts took was that English is going to be the language of record, And that makes things quite simple in terms of appeals, in terms of the keeping of records and so on. And maybe the position of trying to accommodate African languages was something that couldn't work properly because of costs, because of logistics, because one of the things also we had to look at is you don't want a situation where, for example, somebody who speaks English, who is white, or Afrikaans, who is white, might then say, well, I want to also have a situation where the only magistrate who can deal with my case must be one who can speak Afrikaans. Well, English is not a problem because magistrates and judges know English, but with Afrikaans, some don't. So there are some challenges, and I think that in the end, the decision that English should be the language of record on reflection is the correct one.
As an experienced judge, is it correct for a judge to write an opinion for a newspaper criticizing a politician or getting to the public space, not in a form of judgment, but criticizing a politician? Is it right or wrong?
A judge writing...
A judge writing an opinion in a newspaper,
yeah,
criticizing a politician.
a legal opinion,
Is
or
it-
just a comment.
A comment.
I would advise against it. I would advise against it, despite the fact that we all have freedom of expression. I would advise against it.
My last question, what would you regard as a constructive way of engagement of judiciary, legislature, and executive?
In relation to...
You know that we do have the three arms of the state.
Yes, yes.
It's linked to the previous question.
Okay.
You have advised against it.
Yes, yes.
Then I'm posing a question that what would you regard as a effective and efficient way of constructive engagement out of these three arms of the state?
I think they, excuse me, I think that they should have meetings from time to time. But I would think that it's very important that what was discussed at meetings should be, as a general rule, something that can be made public. There shouldn't be a situation where the citizenry wonders what they were talking about and whether, for example, the executive might have been saying to judges, you people must stop what you are doing. You know, these judgments are too hard on us now, or say anything like that. But I think that it should be by way of constructive meetings. But I would also say that it's important for all stakeholders, for all the three arms of the state, for all personalities involved, not to be oversensitive. Some criticism, is inevitable and should be permissible. There must just be certain limits. But I would think that regular meetings between the three arms of the state would be the right forum to raise certain issues.
Thank you, CJ.
Thank you, Commissioner Nyambi. Commissioner Nyokesi.
Thank you, CJ. Good afternoon, Judge Stono.
Good afternoon, Commissioner.
I think there are a few issues that I would like us to debate.
You're not quite clear, Commissioner. Just make sure you speak into it.
Thank you very much. There are just few issues that I would like us to debate. Recently, I think 2 weeks ago, the National Association of Democratic Lawyers resolved that law needs to be decolonized. And inherent to that was, one of them was this question of languages. Now, would you agree with me that it is now the time that the indigenous languages form part of the curriculum for LLB?
I think that is the right thing, and actually it should have happened a long time ago. I know that certain universities have already made decisions in that regard.
Would it then, would you agree with me that times should not be just a question of discretion or option, that it is compulsory that all those who are registered to do law, in their curriculum, they include one of the African languages, that it be made a law? Would you support that call?
I think 1 or 2 universities I read in the media have made it compulsory. But I don't know whether I would go as far as that. If they think that that is the way to go, I'm happy. But I don't. I haven't done enough research to see whether it should really be compulsory or it should be encouraged. But those who have looked at it and said we can actually have it as a compulsory subject, I'm very happy with that.
I understand that when you did your junior degree or LLB at the university, we had to do, for the first time after your matric, we have to do Latin. Why then it would be difficult for South Africans to do one of the African languages?
Well, I know that what you are saying in relation to Latin in university, that applies to, or used to apply to many law students. I did Latin at high school for 5 years before going to university. Well, I know that Latin was compulsory, and because maybe it's a language that is not spoken, which is obviously not the same as other languages that we are talking about, many students ended up taking longer to finish their degrees because of it. So in relation to Latin, there were certain challenges, But as I say, I wouldn't say it should not be compulsory, but I just say that I haven't educated myself enough. I haven't done enough research to be able to say, as opposed to it being encouraged, it should be compulsory. But those universities which have looked into the issue, maybe have conducted research and come to the conclusion that it should be compulsory, I applaud that.
Just a follow-up on what statement that you made. You go to, say, Tembisa or Nkumbu, complain and go to a police station, is opening a case before an African, and in fact they understand themselves very well, but the statement has to be written into English. What can you say on that? Does that make sense?
Well, put it this way. I think that there must be a lot of cases which go in a certain route in terms of outcome because of language problems. I don't know why, for example, in the scenario that you sketch to me, for example, a Zulu-speaking police officer shouldn't take the statement in isiZulu when the complainant or the witness is somebody who speaks isiZulu. And to the extent that they might need to translate it to English for people who might need to understand it but who don't understand isiZulu, that might be something else. But if they took statements in the language of the person, of the witness or the complainant, you know, it would avoid a lot of problems. When I was in private practice, I remember that very often if you were doing a criminal matter, very often you would find that a complainant is ultimately maybe shown to be or accused as a poor witness, because when she or he gives evidence, there are a lot of things that he or she says which were not in the statement. And the statement was taken in English. And sometimes the complainant or witness would say, when confronted by maybe the defense lawyer, but did you tell the police officer who took the statement this and that? Then they'll say, yes, I told him, or I told her, but he said it's not important, you know. And what does the person do? You know, if the police officer says, no, that's not important, they don't, and yet it is important. So I think that probably there are a lot of cases where injustice happens because of problems like those.
In fact, on this point, I mean, the person making a statement.
Commissioner, I'm liberal, but please remember the general, and I normally allow a free flow because it's a leadership position. That must be the 5th or the 6th.
I think this last question.
Yeah, no, it's okay. I was just cautioning.
Now, this last question, in fact, is unrelated. There are, I know judges won't be happy with me on this. Do you think practice is like referring to judges as my lord, my lady? Is it still an appropriate thing to do at this stage?
Well, I think there is a lot of people who kind of think it's not acceptable. For me, judge or justice is just good enough.
Thank you, Commissioner Nokesi. Commissioner Fori. Your mic.
Good afternoon, Commissioner.
Two issues that you touched on relating more to the practice side of things, I would just like to touch on with you. The one is you referred to motion procedure as vis-a-vis action procedure, and motion procedure being swifter and quicker. I think there's a tendency amongst practitioners to wish to go the motion route because of the fact that it is quicker, except when there are disputes of fact. And over and above that, when you proceed in a motion matter, well knowing about the possibility of disputes of fact, you might risk getting a court order or a costs order against your client. I understood you to say that the motion route, because of the quickness thereof, should be encouraged. How do you envisage dealing with those, I think, almost unsurmountable problems of disputes of fact, for example?
Yes. Well, I think if we were to introduce a regime in terms of which all matters that are brought to court were to be brought by way of motion, certain things would have to change. And that includes, in that situation, you wouldn't apply plus con evens the way it's applied at the moment, because you apply plus con evens the way it is applied because the applicant makes the choice of bringing proceedings by way of motion proceedings instead of action. Whereas the regime that we would be introducing would be one where the litigant would not have a choice, but would be compelled to bring it. But what we would then do when all the affidavits are in, and that would fit in with case flow management, when all affidavits are in, the parties must then look at what disputes of fact there are, which is what they do even now, because at a certain stage, lawyers have got to say, do we ask for the matter to be referred to oral evidence or not? Can we win without oral evidence? Parties would then have to look at what disputes of fact there are. And I think what would happen that in some cases, as it happens even now, you might see that there are disputes of fact A, B, C, D, but there is this point on which there is no dispute of fact, and on that point the matter can be disposed of. In which case then you can go that route without going to oral evidence. But where one of the parties feels that there is no such point which can dispose of the matter without oral evidence, what you would then say is, let the matter go to oral evidence only on the limited issues which are in dispute, because the rest is common cause already because of the affidavits that have been filed. So I think that there would need to be some change of how we deal with certain issues relating to motion court, but I think it is doable.
Thank you. Interesting submission. I have to chew on that a bit, but it's interesting. You've referred to RAF matters and the difficulty with the matters being settled very late. I don't know whether you will agree with me that that mostly refer to the quantum part of such a claim, not necessarily to the merits part. Now, one of the things that I've advocated for many years and haven't had much success about it is that the rules still currently provide that expert summaries have to be submitted 10 days before the trial matter. Notice only has to be given of an expert 15 days before a trial matter. And then it is almost unthinkable nowadays that one will go to court where there are various experts on both sides without getting joint minutes. Now, if you look at 10 days before the trial date and between 10 days and the trial, joint minutes still have to be obtained. It's no wonder that matters get settled on the steps of the court or at the calling of the roll, or has to stand down for instructions, etc. One thing that I've said for years is I think it will almost solve that problem if those time frames are moved back considerably and the 10 days become 2 or 3 months or whatever the case may be. Then there's more than enough time to resolve those issues, get proper instructions, make proper tenders, and dispose of the matter well in advance, which will save enormous costs. Is that something that you will promote?
I would promote that. You know, I think what we need to do, we mustn't be, well, while the rules are there, we are bound by them and have to comply with them. But we mustn't be married to the rules, if you will. We have got to say to ourselves, what is it that needs to be done for us to achieve an efficient trial system? And identify all the things that are problematic. And that includes exactly what you have said. And that's in line with what I said when I was saying that there should be a discussion about the the possibility of saying all matters must be brought to court by way of affidavit. Because if you move the time periods and say those expert opinions must be finished earlier or notices must be finished earlier, the earlier a litigant gets the opinions of his or her experts, the better, because then they know where they stand. But if that is left till late, to 10 days before or 20 days before the trial, and then at that stage they discover that actually they have been pursuing an amount that they can't justify, then you find that the matter is settled there. But if they had a year before obtained that expert opinion, they could have negotiated a settlement from a very informed position, and that would have promoted a settlement. So we need to say, yes, the rules might be saying this, but what do we want? The rules must serve us, the public, not us serving the rules. So I would go along with that.
Then we're on the same page as far
Yes,
as that
we
is
are.
concerned. Thank you, Justice.
Thank you.
Thank you, Chief Justice.
Thank you, Commissioner Fourie. Commissioner Didiza.
Thank you very much, CJ. Good afternoon, Judge Zondo.
Good afternoon, Commissioner.
Well, there are two questions I have. One was already canvassed earlier by Chief Justice in respect of your work in the Labour Appeals Court as well as in the Labour Court on how you promoted gender and race representativity, but I'll speak more on gender. It would be interesting for us as this commission to know what programs did you put in place to ensure that you advance the representativity of women in the court. The second question relates to the position we are applying for. I know when we are responding to CJ, you said you will support the Chief Justice, but there are certain things that you will do. If I were to ask, sitting where you are in the Constitutional Court, what would you say are the immediate challenges confronting the court to date? Thank you.
Thank you. Thank you, Commissioner. Well, when I was Judge President of the Labour Appeal Court and Labour Court, one of the challenges I faced, and this applied particularly to black lawyers and women, was that while the Labor Relations Act, under which judges were appointed both permanently and for acting purposes, required that, for example, for the Labor Appeal Court, they needed to have special knowledge of labor law. The reality was that a lot of black lawyers and women had not had a lot of exposure to labor law. But I must also say that even among whites, there were not too many white lawyers who were very involved in labor law, but the situation was much better compared to black lawyers and women. So what I did was to try and identify practitioners that I thought were sound in law, because I believed that if a practitioner was sound in law, then if you gave him or her an opportunity in any field, specialized field, in due course, they would be fine. And so I identified a number of practitioners. Some of them had very little, if any, exposure. but they were sound as lawyers. And I brought them into the labor court. I know that at a certain stage I was being criticized in certain quarters, the criticism being that I was bringing people into the labor court who did not know any labor law. My position was that if we were to wait until they knew, black lawyers and women knew labor law, then there would never be any change. Because in order to know labor law, apart from any studies that you might do at university, you needed to be given work, labor law work. A lot of black black lawyers were not getting that work, and a lot of women were not getting that work. So things would just not change. So I thought that this is what one needed to do. And also I also approached judges in the high courts because, for example, for purposes of the labor appeal court, somebody needed to be a high court judge before they could sit there. I approached them, I spoke to the heads of courts about the program that I introduced, in terms of which even high court judges would come and act in the labor court or labor appeal court to get exposure, so that after a certain period of time, they could be comfortable in labor law. And that program became very popular with both practitioners who were not judges and judges of various high courts. They came and participated. That is what I did. With regard to the second question, Commissioner, one of the challenges we face in the Constitutional Court, of course, is the question of transformation in terms of gender. I believe that a lot is being done, but it's just not going the way that we would all like to happen. But also another aspect is that in 2013, the jurisdiction of the Constitutional Court was expanded considerably. The Constitutional Court moved from a point where its jurisdiction was limited to constitutional matters and constitutional issues, to those plus any matter that has got an arguable point of law of general public importance that the court might decide deserves to be heard by it. Effectively, that means that there is no branch of law that you can't find a matter and bring to the Constitutional Court, as long as you can identify an arguable point of law of general public importance that the court might consider deserves to be heard by it. I don't have the figures, but it would appear that in 2010, 2011, for example, we might have had about 100 and something new matters that came to court. But I think 2016, we're already running, I think we ran up to 300 and something. I think the work probably has tripled that we have to do. And one of the consequences of that is that because the number of judges remains the same, whereas the work has tripled, there might be some delay in disposing of some new application matters. And one of the things we have been considering is whether we should not have a situation where in regard to new matters, we should have a few of our colleagues, maybe 3, basically deciding whether a matter should be entertained or not. At the moment, the position is that all 11 justices must take part in every matter, because that's what is required. Of course, we can sit 8, but which is the minimum for the quorum, but we just take part, all of us. The problem with saying, look, let's have only 3 decide, is that that would be contrary to the Constitution. The Constitution at this stage contemplates that all of us should take part in those decisions. So it's a continuing debate. We are aware that there were very powerful reasons why the drafters of the Constitution said the Constitutional Court must sit and bank. But there are these challenges that we are facing. We keep on looking at them, but we wouldn't be able to have a fewer number decide some of the matters without a constitutional amendment. So, yes. Thank you.
Well, I think I would want you to say more about Commissioner Didiza's first question,
Yes.
because people do not know what you and I know and other judges. They are wondering. Look at how many women are in this country. What is so difficult in ensuring that courts reach 50-50? What is so difficult in ensuring that even the Constitutional Court has a 50-50 representation at least of men and women? And I think the Commissioner's question is, what could be done to ensure that at high court level, at specialist court level,
Yes.
and even at SCA and Constitutional Court level, women are more meaningfully represented than they are right now? Are we perhaps as judges or the leadership of the judiciary rather too conservative? Are we dragging our feet? Are we not, don't we have ideas as to what is it that need to be done differently to fast track the project of ensuring that there is meaningful or more meaningful gender representation? What are the challenges? What could be done
Yes.
to improve on what has been done already?
Yes, thank you, Chief Justice. I think that the approach should be a multi-pronged approach. One of the things that may need to be done, and I think it was done some years back, was to provide some special training to make of identified women practitioners who have reached a certain level. Training that if you give them, you are going to expedite you are going to make sure that soon they would be ready for appointment to the High Court, for example. And of course, if you do that, then that will have an effect in due course on the Supreme Court of Appeal and the Constitutional Court. The other one is a point which you, Chief Justice, have mentioned in some of your speeches, and that I have also raised in the past, the issue of black lawyers and women being given legal work that will give them the experience that they need in order to be ready at a certain stage to go to the bench. Now, Chief Justice, Mr. Semenya is not here, but some years back while I was Judge President of the Labour Appeal Court, being worried about this, being concerned about this issue, I called together some practitioners. I think there was, in some meeting, Ishmael Semenya was representing the bar, and there were some attorneys. We had a meeting. What I was looking at is whether we could have a program that could be sold to certain companies, big companies, which, for example, have got legal departments, and say to them, can we have an arrangement in terms of which you will take certain black lawyers and women, and for a certain period, keep them in your legal department and let them work in your legal department, and in due course they would come out, go back to their practice. The idea being that then the company would feel confident that this person has worked with them, this person understands their kind of work, and that then they could feel quite free to give them work. And we had, I think, two attorneys, one being a woman from Joburg, another one was another African attorney. The woman went and spent a certain amount of time, I think about 3 months, if not more, with a big company that is well known in South Africa, after an arrangement had been made. And she understood their work and everything. But once she went back to her office, they didn't give her work. And that was very discouraging. So one, I think that something concerted needs to be done to make sure that a lot of women who are in practice get a lot of work. I have said on other occasions that, particularly in regard to government departments and parastatals, we need them to do to women and black lawyers what trade unions did to me. And trade unions, including those who were in COSATU and others were not in COSATU, said to me when I was still with a white law firm, they said, we want you, when you feel you are ready, to go and be on your own or with other black lawyers. I have a black law firm that we can give work. And when at a certain stage I left, and they gave me work. And at that time, I think they didn't have a lot of ground to have confidence in me, but they basically let me do their cases, brief counsel if I want to, not brief counsel, and do the cases myself if I wanted to. And that helped me quite a lot. So it's an investment that needs to be made on a long-term basis. But also in terms of the actual nomination of candidates, women, we all have a duty to nominate when there are vacancies that are advertised, whether it's in the constitutional court or elsewhere. We ought to look for women who are suitable and nominate them. But quite often, there are very few. I think at the moment, in this round of interviews that will happen, I think there's only one woman. I think last time, I don't know if it was just men only. So we all have to say, what are we doing? Because every one of us has a chance, has a right to nominate.
Well, based on your experience, both at the labor courts, the High Court in Pretoria, and the Constitutional Court, do black practitioners and women get as much work as their white counterparts from government departments, state-owned enterprises, and the private sector?
No, Chief Justice, no, not at all. And unfortunately, it's continuing. I mean, this issue has been raised over years, and I know that groups of black lawyers and women talk to certain government departments and so on in provinces and nationally. I don't know the actual facts, but what I do know is that when we sit in the constitutional court and matters come before us, so often it's just white.
It could be as many as 20, 26
Yes.
advocates,
Yes.
excluding attorneys,
Yes.
from government departments,
Yes.
state-owned enterprises,
Yes.
private. They would just generally
Yes.
be white. Is that not so?
Yes, that is
And
so.
very few white women in the, very few women, white
Yes.
women in the process.
Yes, it is simply so, and it's just unfortunate. I don't know what needs to be done, but really, at least with government and parastatals, I don't know what excuse there is. With regard to private companies, they might just be deciding, it's my business, I decide what I'm going to do. But with government and parastatals, it's the public's work.
How challenging, if it is challenging, is it to appoint people without such exposure to the higher judiciary?
It's a challenge, Chief Justice, because one has got to do a balancing act. If you appoint somebody to a certain position who is not ready, you might just be setting them up for failure, and that's not good. So one has got to strike a balance. You mustn't wait until people are perfect, but at least they must reach a certain level where you say, look, they should be fine.
And in terms of taking those who are not quite there to the high court, specialist courts, what impact does that have on their possibilities of moving from that level to the Supreme Court of Appeal and the Constitutional Court?
Yes, when they've got to take some time because they've got to get some experience. They're going to walk a longer journey before they are ready to go to the Supreme Court of Appeal and to the Constitutional Court. But we should continue to try. I don't know. I was thinking the other day with regard to, for example, one of my concerns in regard to transformation is this, that there are certain branches of law which continue to be dominated by white lawyers and white judges. You go to the law reports, if it's a tax matter, if it's a patent law matter, it's going to be a white judge, male, who has done the judgment. There should be no branches of law to which certain sectors of our people are excluded, from which they are excluded. Now, one of the things I think that could be done, for example, is that when, for example, I have no experience in patent law, but I'm interested and I'm passionate about it, there could, for example, be colleagues in the division where I am who have more experience, and arrangements can be made for me to benefit from them, but also those who have retired, who we know might have that experience. We say, are you prepared to be available to this judge and that judge and that judge, so that they can consult you whenever they have a matter such as this, and they could even draft a judgment, let you see it, and then you can point out if it is fine. So we might need to look at doing those things and use retired colleagues, because I'm sure for purposes of transformation, a lot of them should be interested in assisting.
To play a mentorship role. of
That's
sorts.
right.
Commissioner Nkosi Thomas?
Thank you, Chief Justice, and good afternoon, Justice Zondo.
Good afternoon, Commissioner.
Thank you. During the questioning, as it were, by the Chief Justice, you spoke about your vision, and you mentioned that as part of that is the modernization and digitization of the court. So I listened with interest to that because I think it's somewhat long overdue. So I do have a few questions to put to you in that regard, please, Justice. The first is, when should we expect that to go live? In other words, the digitization. And the second is, which courts perhaps are being targeted as part of that project? And the third is whether it's part of your vision to use this modernization project to enhance access to justice. And one asks that question bearing in mind the acute low levels, as it were, of literacy, particularly in the rural areas. Thank you.
Thank you, Commissioner. Let me correct one thing. It's not my vision in the sense that I came up with it or I'm coming up with it. It is, I think, it is the Chief Justice's vision, and he and the heads of courts have set up a committee chaired by one of the judges' president to look into this project. And I was present at one of the heads of courts meeting where it was discussed, and there were experts who came to demonstrate to the heads of courts how it would work. So I embrace it. It's not my idea, but it's a good idea, and I embrace it, and I'm willing to play whatever role I can play. I must just immediately admit that I'm not as technological as other colleagues might be, but I'm willing to play a part in that regard. I took the trouble to speak to the judge president who is chairing that committee to find out what's happening about it and how far. He indicated to me that they were hoping that by end of this past financial year, they would have got some funds, but they were not able to get funds. They are hoping that, I think he said definitely they are getting funds in the new budget. And what they are looking at is to start it as a pilot project in certain high courts. I'm not sure whether they have identified which high courts they would start with, but I have a suspicion that it would involve Gauteng because they are very big courts. In regard to whether it's part of access, yes, it is part of access to justice as far as I understand it. Thank you.
I don't intend to take too much time, but moving now to another topic briefly, and it's really just a comment, Justice Zondo. One has had the privilege and pleasure of touring the Shanghai High People's Court and all of that. And what they do there is that they do exactly what you're suggesting ought to be done in relation to their pleadings being affidavit-based, and they have achieved cost and time efficiencies. I thought I should just mention that. Thank you.
No, thank you very much. Actually, I think the Chief Justice made sure that, I don't know whether it was this committee that is dealing with the matter, but they visited, I think, certain countries to see how they deal with this and to see what they could borrow from them and mix with what we have to produce something that can work for us.
Thank you, Commissioner. Doctor.
Chief Justice, one of the fathers of our constitutional democracy, Oliver Reginald Tambo, observed that racism was used to justify conquest, disposition of our people of the land and its natural resources, justify turning African people into instruments of labor, and justifying white minority rule. Now, we have a situation where African kingdoms, queendoms, were conquered at the end of the 19th century. Now, the Union government then established, passed the 1913 Act, which left African people with only 7% of the total surface of the country, which was increased to 13% in 1936. Now, do you think that a state based on this fundamental injustice, which used that fundamental injustice to dispossess people of their land, and then do you think that the cut-off date of June 1930 is fair and just? And do you think that the Community Property Act, which gives individuals the right to claim land other than the kingdoms and queendoms who fought to defend that land and lost it, that is fair to allow individuals, a group of individuals, to claim the land other than the people who lost the land? Second question, the Constitution, in my understanding, makes English and Roman Dutch customary laws equals to the African customary law. But how does that equality operate in practice when all our lawyers are taught English customary law and Roman Dutch customary law and not African customary law? Now, how can we then dispense justice to more than 80% of the population when their law is not taught? Doesn't that make our lawyers Eurocentric rather than Afrocentric and at the expense of the rights of the African people? Third question before the last one. It took us more than 15 years to pass the Traditional Courts Bill. We're still busy with it. Now, there are community courts which were developed by the people, but it appears that traditional courts and community courts are not taken seriously. What would be your attitude to expediting the establishment of community courts and traditional courts and community courts? I also saw a very strange thing in the proposal by government to say that anybody who is not happy with the traditional courts can opt out. Do you think that it should also be permissible that when I appear before courts and somebody wants to apply English law to me, I say, no, I'm not English, I'm opting out? Would that be, in your view, permissible? Lastly, Judge, you are very well qualified, well experienced. I'm just wondering, where were you between 1985 and 1995? Because it doesn't appear that you studied any constitutional law. And what do you think qualifies you to be a Deputy Chief Justice in a constitutional court when you have not studied any constitutional law? Thank you.
Okay, shall I start with the last one? Well, between 1985 and 1995, I was in Durban, practicing there. And during that time, 1985, I was also doing my LLB.
The mic is off.
Sorry. Well, let me say this, Commissioner. I do not hold the view that you can only learn a branch of the law because you attend university and write exams and have a degree for it. There are many lawyers who did not study certain branches of law at university, but who are very good in those branches because they have taught themselves, they have read, they've done cases that have got that involve that branch of the law. Let me make you an example about myself. I have done a lot of labor law work, but quite frankly, the labor law that I studied at University of Zululand, which was called industrial law, really didn't give me much. And where I really learned labor law was at Mrs. Mklenge's office. And there was no labor lawyer in Mrs. Mklenge's office. Mrs. Mklenge, one of the reasons why, or the main reason why Mrs. Mklenge took me as an articled clerk was that she said, you have been at the Legal Resource Center, they do a lot of labor work. Here we have, so you must know some labor law. Here we have a lot of labor work from the political work that we do. You know, a lot of trade unionists were involved in the struggle, and they would bring the labor work. And she said, none of us here knows this field. So I want you to start a labor law department. And she gave me a big office as an article clerk. Those who have done articles know that usually when you are doing articles, you won't have an office of your own. You will share with somebody, or you move from one office to another office. At least during our times, I don't know now, maybe things have changed. She gave me a big office and said, I want to make sure that when workers want to consult with you, there's enough space. She gave me a secretary. Those, I don't know now, during our times, if you were an article clerk, there was no way you could have your own secretary. You know, she gave me a secretary and said, I want you to devote yourself and do this work for the firm. And she said, you must identify people who have labor law experience because you can't sign pleadings. We have to sign them, but we don't know labor law. So when we sign them, we'll depend on you that we are signing the right thing. So you must check with other people. And she said, tell us what books you need, what law reports you need, we'll give you. And that's what happened. And I read extensively. So the labor law that I got isn't so much labor law I got at university. It's labor law I got in practice. And then, of course, we all know that the first team or justices of the Constitutional Court in '94, a lot of them would not have had much, would not have done constitutional law as we know it at university, you know. They would have done some other kind of constitutional law where parliament is supreme and so on. But we all know how well those justices of the Constitutional Court, without having had formal qualifications in constitutional law, how well they performed and how much they commanded constitutional law. So that is my answer in regard to that. In regard to the question of Roman Dutch law, English law, and customary law. I take the view that we don't give enough attention to African customary law. And I include myself in that, because why is it that I've never written an article on customary law, our own law? I've never written it. But we should be promoting it. And we should be doing quite a lot in regard to it. But I hope that at some stage I will write something on African customary law. With regard to the Traditional Courts Bill, I'm not sure to what extent I'm at large to express any view on it, seeing that it might well come before us if there are controversial issues. My sense is that I probably should try and avoid expressing any views on it. I might have left out one or two of the questions, I'm not sure.
Please switch on the mic, Doctor.
No, I think you have done justice to my questions. I just want to put one last follow-up. Whether or not it shouldn't be compulsory for all LLB students to take customary law and also an indigenous African language, if we are serious about treating indigenous African law seriously. And the last point is about the participation of judges in debates. I take the view that judges should be able to address conferences and express opinions on certain legal issues as part of the public discourse. What would be your view?
Well, with regard to the first one, I'm sorry, with regard to the first question about whether it should be compulsory for African customary law to become, for law students to take African customary law, I think I would go along with that. But with regard to the language, whether it should be compulsory, I think another commissioner asked me the question and I gave the answer. If a particular institution has done enough research and says it should be compulsory, then I'm happy. But I simply said I haven't been exposed to any research that would make me feel comfortable to say it should be compulsory.
Commissioner Schmidt, thank you, Doctor.
Thank you, Chief Justice. Judge Zondo,
Yes.
I would like to give you an opportunity to clarify, I think, a position that has been reported in the media, under media coverage by the Democratic Governance and Rights Unit. And, you know, it's an opportune time just to explain what the circumstances were. But it's been alleged, approximately during 2007, that an amount of about 1.2 million rand were paid to you, then as a judge of the Labour Court, not yet a judge of the High Court, but that your conditions of service and employment were basically the same. Now, that's the allegation. A, is it correct? And B, would you like to put it into context? Thank you.
Oh, well, that issue was raised. I'm not sure if you are aware, but you should be aware because I think you were here in 2012. You were part of the commission in 2012. That issue was raised. I responded fully to it. I think what had happened was that somebody misunderstood how regulations relating to S&T work. I responded fully to it. The commission even has the document where I set it out. I said, in terms of the regulations, you could ask the Minister of Justice to make a certain city your headquarters, And this is what I'd asked Dr. Maduna, and he had agreed, and that then entitled me. That was given, that explanation was given, and as far as I'm concerned, it was accepted by the commission, because after the explanation had been given, no member of the commission during the interview was interested or asked me any questions about it. So that from my point of view was settled.
Secondly, thank you, Judge. Secondly, your issues concerning, or the answers you gave regarding the experience to be required by judges or acting judges. We are about to interview later on this afternoon
Yes.
a very eminent judge who I think was about 35, 36 before she became a judge. And there are many other judges we can refer to whom has not had the benefit of all the experience. So I think you would at least agree that experience on its own is not the only criteria. There are many more other
Yes.
criteria in terms of which you would determine whether someone is suitable or not.
Yes. I agree.
Commissioner Malema?
Thank you very much, CJ and Judge Zondo. Let me ask very simple questions here. Now, can you briefly describe your relationship with Chief Justice? I heard him declaring.
Yes.
Can you just tell us what does that mean?
Well, we are friends. We have been friends for a long time. But one of the characteristics of our friendship is, for example, that it doesn't affect our work. If at our conference in court I'm out of order, he tells me that I'm out of order, just like he tells everybody who is out of order. We agree on certain points of law in terms of judgments. Sometimes we disagree. One of the cases that I can remember where he disagreed with me was Toyota that was handed down, I think, last year. I stood alone in that matter and found for the employer. Everyone else, including him, was on the other side. When I was acting in the constitutional court before I was appointed, he wrote a judgment in which, with which I disagreed. Justice Jafta wrote a dissent, and I went along with Justice Jafta and not with him.
Judge Zondo, you're not answering the question I asked. I want you to describe your relationship with the Chief Justice. He says he's your friend, not those things of professional relationship. Your personal relationship with Chief Justice. He says you met first year and all that.
Yeah.
And we heard that from him. I want to hear it from you. What is your relationship? You first year, and then what happened, and like that.
Oh, okay. Well, we met at university in 1981, and we did the same degree, which took 3 years. We were friends, but not as close friends as we became later on, but we were friends. In 1984, he went to do his LLB at University of Natal. I worked at the Legal Resources Center, and then in 1985, I connected with him again at the University of Natal. He was finishing his LLB. I was starting my LLB, but also I was doing articles. After that, there were a number of years when there was not as much communication between us because of distance, because I was practicing in Durban, he was in Northwest. I think at some stage he was in Johannesburg. And in 1999, or 99, yeah, he came to act in the Labor Appeal Court, and we reconnected. And later on, he and others were appointed as judges of the Labor Appeal Court. After some time, he became judge president. I was judge president already. I was not at his wedding. He was not at my wedding. I don't know whether you need anything more.
Well, Chief Justice, I've got a lot of questions, and I will ask that, if it's possible, Judge, if you can just give us a brief responses so that I can canvass all of these questions with you. Now, is your friend to a point where I can say he's your brother?
Well, people use brother in different contexts. I wouldn't object if anybody said my brother, or if I said brother and he said my brother.
May help the process, Commissioner, but only if you permit.
No.
Okay,
Chief
carry
Justice,
on.
no. Is Chief Justice your brother?
Biologically, he's not my brother.
No, in the context of what we debated, me and you now, can you refer to, okay, maybe let me ask it differently. Is either you or Chief Justice, is it one of you, are you the godfather of each other's children or anything of that sort?
No.
Do you go to each other's birthday parties, dinners at home, and friendship like that?
Well, I've visited him in his home with my wife. He has been to my house with his wife.
Did you share a room with Chief Justice at the university? Did you stay together in the same room at the university?
No.
So this friendship is not a close friendship, because the way you are describing it, it's like it's a non-existing friendship.
Well, you see, it's, I think in the past few years, it's been much stronger than it may have been during certain years, but we regarded each other as friends. I mean, you may legitimately say how come you were not at his wedding if you were his friend, you know, so, but yeah.
And then Commissioner Didiza, your relationship with her?
There is no blood relationship. I met her in the 80s, and we have known each other since then. I've been to, I think I was at her wedding. There is a function which I attended at her house at some stage. But she too, I mean, I'm seeing her today. I don't know how many years I haven't seen her other than seeing her on TV. I presently don't have her phone number. I doubt if she has mine, but we regard each other as friends nevertheless.
Then anyway, I will canvass it later with the colleagues, because the earlier disclosing by these two colleagues described that you've got some family bond, like your family friends, your friends. And I was going to ask you a question. Do you feel comfortable being interviewed by friends?
Well, I have absolutely no problem with being interviewed by friends if it's friends who are professional, who will do their job properly. So I would have a problem if I thought a particular friend was somebody who was not like that. I mean, I've just told you that with regard to the Chief Justice, we debate issues, we disagree, and that's it. In court, sometimes he goes with others, and I go with others in a judgment. It's just not a problem. We understand that friendship mustn't affect integrity. If I don't agree with him, I don't care if all the other 9 colleagues agree with him. I will stand and say, I don't agree. And that's what I said I did in relation to another colleague in the Toyota matter. I didn't care that I was the only one who was saying, in this case, the employer must win. And there are other matters where I take my stand, and that's it. And other colleagues do the same.
But you know, I'm scared that somebody else who knows of this friendship, and we appoint you to go and work with your friend, this is going to be seen like a brusk-up type of an arrangement. Will that not damage the good image of the Office of Chief Justice? If friends are seen to be exchanging favors here and legitimizing those favors through a legitimate process like this?
I think that those who know me, those who know the Chief Justice, and I think he's quite well known, would not really be concerned in the list. And I believe he, just as Commissioner Didiza, are people of integrity. I don't expect them to do me any favor. They don't expect that I would expect that. What is important is that those who know us, they will know that it's not nothing untoward is happening.
I'm talking about perception, not the people who know you. I'm not saying anyone is doing you any favor. I'm not saying anything about bad about Chief Justice, but from a distance. Here are 2 friends running the most senior offices in the Constitutional Court. And perception is everything in public office. Don't you think that this will have a negative impact on the good image, real or not real? But me and you must always be, and that's why I'm here. I'm always concerned about the image, the integrity of this institution called the judiciary. Don't you think that will have a negative impact?
Well, I think it's possible that some people might think like that. But I think that if people took the trouble to inform themselves about this process, which by now I think is quite well known because the JSC has been there for a long time, they would know that it's highly unlikely that his influence or his friendship to me would sway all these commissioners or the majority of them to vote for me. And I think that people will attach special importance to the fact that he has declared that friendship for all to see, to say, this is the position. He even said, you can ask him a lot of questions, referring to me. So, yes, it may be possible that certain people would have that perception, but I think that if they took trouble to inform themselves about the nature of this process, their concerns should be laid to rest.
Now, the appointment of Justice Nkabinde as an acting Deputy Chief Justice, what did it do to enhance the good image of the judiciary?
Well, I think what was important was, as far as I'm concerned, was that it sent the message that a woman could be appointed to that position, even if it was just in an acting capacity.
And that suggested we've moved one step forward in a right direction, particularly on issues that you spoke very passionately about of gender.
Please just repeat that.
The appointment of a female into that position suggested that we've moved one step forward in a right direction, particularly as it relates to gender issues.
I think so, if you can say that of an acting appointment, but I certainly, if it was permanent, that would be completely valid. But it may be that even if it's an acting one, one should say the same thing.
No, but I'm asking about an acting position. I'm happy that you agree with me that if it was permanent, it would have been even more positive. But I'm saying her appointment, acting there, being a female, it was a one step in a right direction.
Yes.
And if we're to appoint a permanent female in that position, it will actually send a more stronger message that we are committed to empowerment of women. Is that correct?
Of course.
So if that is being the case, and having fought for women all these years, why wouldn't you decline your nomination and suggest that there must be an empowerment of a female?
Well,
and every time people ask questions, I never cause any problem. I keep quiet and listen to people's questions, no matter how uncomfortable I am with those questions. And I should be given the same respect, Chief Justice. Not here to please anyone. I'm here to ask questions.
Well, Commissioner Malema, I am here because I understand that the President wrote to the JSC and said he is considering appointing me as Deputy Chief Justice, and he would like to hear the views of this body. I thought that I don't have the same information that the President might have had at his disposal in making the decision he made. But when I was told that this body is required to give its views about me, I said I would come and be available for the interview. I would be speculating if I tried to look at why the President made the decision that he made. But I didn't think that I could decline to come here and make myself available in circumstances where I'm not privy to any information that the President might have. I am aware, of course, subsequent to that in relation to the Supreme Court of Appeal, the President did nominate a woman to be president of the Supreme Court of Appeal, a position that has never been occupied by a woman. But as I say, I don't want to speculate about why the President made the decision that he made.
We're still going to deal with the issue of the Supreme Court of Appeal, and that is another level of the court. And now we're dealing with the highest level of courts. And me and you, we just agreed that the appointment of an acting female was one step forward in a right direction. And therefore, if we're to appoint a permanent male in a position where we had an acting female and we're moving in the right direction, don't you think we'll be taking 2 steps backward when it comes to issues of gender?
Well, it might, I don't know if it's true, but it might look like it's not the step that goes in the same direction as the appointment of a woman colleague as an acting Deputy Chief Justice. But I don't have the facts which may have been before the president to make the decision that he made. And I can't say what influenced him. It may well be that if I were to be privy to the information that was before him, I might say, no, this is not a good decision. Or it may be that I would say, no, now I understand. I just don't have those facts.
Can you take us through your involvement in community issues?
Well, I've been on the bench for about for 20 years now, and I live in Durban, and but I've been in Gauteng during this period. I have not been involved in community issues as such during that time, simply because spending so much time away in Johannesburg and then skipping a weekend, going to Durban, spending only weekends at home, there hasn't been much time for that. But I have had engagements with organizations such as BLA, for example, and have made some suggestions on some of the issues that they should deal with, for example, in relation to the issue of transformation in the legal profession. I made some suggestions about the setting up of a legal transformation fund to try and assist with regard to transformation. So in terms of, I'm afraid my circumstances do not permit me to play a lot of role in community organizations.
No, even before you became a judge, have you
Yes.
been involved in any community issues, development, organizations, even before, not only when you were a judge?
Yes, no, I was involved. For example, at a certain stage, I was working in a township in Mpangeni, which used to be called Eskawini. I think they call it now Eskaleni. I was involved, for example, there in regard to, in 1984, I was there. There were issues that trade unions and communities were involved in. That's where, for example, I met the current premier of KZN. That's where I also met the previous MEC for Economic Affairs, Mabuya Kulu in KZN, when I was working in Mpangeni. And in Durban, there was a time when Lamontville Township was having a lot of civic issues, and that's where I met Lechisa Tsinori, the Deputy Speaker. I was with Mklenge's office at that time. I think there may be others, but I was not prominently involved. You know, I took part when there were certain issues, marches, protests, and so on.
And then you said you met Chief Justice around 81 or so. And
Yes.
that is a year where the youth were called upon to render apartheid ungovernable.
Yes.
South Africa ungovernable and apartheid unworkable. Were you a student activist during those times? Because almost all black young people at the time played some role during that time.
Well, when we came to the University of Zululand in 1981, if I recall correctly, the SRC had been banned. And it remained banned for the rest of our time when we studied there. Notwithstanding that, I joined, for example, you know, at universities, they used to have then, I don't know if they still have now, they would have a society of this, a society of that. There was what was called a Society of Humanities. It was chaired by somebody who later became an advocate, I think in Pretoria, but he's late now, Mr. V.W.V. Duba. He was quite active. In a certain way, it sought to try and do something in relation to issues that otherwise an SRC would take up. But it was very limited, it was very difficult. There was a lot of suppression. I was its secretary for a certain time. So I took part in that. But during that time, there was a lot of repression in terms of student activities at that university. When I was at University of Natal, I didn't take part in a body like the SRC, but I took part whenever there were demonstrations, or that was during the time of the UDF, when, for example, one time the UDF had a rally. I don't know if one calls it a rally if it's in a hall, but it was at the student union. I think the then president of COSATU, and COSATU had just been formed, Mr. Bahayi, I think he spoke there. Mr. Patrick Likota spoke there. Begi Cele was an interpreter there, or translating. Reverend Kundu was there. And I think there would have been also Mewa Ramko Bin would have been there. So I took part in certain activities, but might not have been part of any particular body at a formal level. And this must be viewed within the context also of the fact that I was studying and working at the same time.
Well, Justice Zondo, I think we need to clear up a few things.
Okay.
I thought I was harsher on you than all other colleagues, considering the comments I made on your Toyota and Hendo judgments.
Yes.
I wouldn't have been that hard with any other
Yes,
colleague.
you were very harsh.
But let's deal with gender representation, because it's a thorny issue, and it's worldwide. My sense is that it's such a difficult issue that even political parties will find that the president is a man, the deputy is a man, the secretary general is a man, the spokesperson or even the treasurer is the man in South Africa. Is that not so?
No, it is true, Chief Justice. It's we need to we also need to just accept that we are, many of us, we are not we are trying to do our best, but
Yes.
it's not easy. And we must just keep on trying, we must keep on identifying where the problem areas are. It's not easy, but what you have said is actually true.
They've probably considered declining, but they are there.
Yes, 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 yes.
Now, on the question of friends working together in the same environment, wouldn't it be problematic if one of them lacks integrity or is corrupt? Because then the risk is he or she would influence the other. Or if they are both corrupt or both lack integrity.
I think that there would be that danger in that situation.
How dangerous could it be for men or women of integrity who are friends to be involved in the same setting? How dangerous could it then be for the institution? What possible harm could arise?
Chief Judge, is that
And we are
if they
talking
don't have
about an
integrity?
informed, from a perspective of an informed, reasonable person, not an ill-informed and therefore unreasonable person.
Well, if one is talking about people of integrity, there is really no problem as far as I'm concerned. And obviously, if you're talking about people who have no integrity, then of course there is a serious problem for an institution.
Yes. Very well. Commissioner Msomi?
Thanks, Chief Justice. Good day, Justice Zondo.
Good afternoon, Commissioner Msomi.
Justice Zondo, I've got 4 questions for you. I never thought one day I could sit this side and pose questions to you. Having been interviewed by you before for the PA position at your firm.
Now I remember that.
I'm not going to give you a hard time. How would you describe your management style or your leadership style, given the fact that you are going to occupy a leadership position?
Well, I think that I'm very consultative, but I draw a line. I think I take the view that when you are a leader, you must not be scared of making decisions. And you must know that sometimes you must make decisions that are unpopular. And if some of the people you lead are your friends, sometimes you will make decisions that they will not like. But it's part of being a leader. You have made to make decisions. One of the worst things I always say is a situation where a leader fails to make a decision. You must make a decision. It might be right, it might be wrong, but you must make it and you must give it your best shot. So even when I was judge president in the Labor Appeal Court and Labor Court, I would consult my colleagues on a number of issues, but I always said to them, on certain issues, I'm consulting you and I would very much like your views. I might change my prima facie view, but in the end, I think that I will take a decision that I believe is in the best interest of the institution. Sometimes it's not the decision I want, but if I think it's the best for the institution, I would go for it. I think that I probably, if I am appointed to this position, I probably should try and delegate more than I may have been. I've had some challenges in terms of delegating, so I think that it's something that, but it's something that I've identified. And once you have identified something, that's positive because then you can do something about it. If you haven't identified it, you won't do anything about it because you don't know. So I think my leadership and management style is very much consultative, but in the end, if the decision is mine, I will not shirk my responsibility.
Thank you for that. Some argue now that the bench has really become a contested terrain. There are all sorts of political pressures and so on. Is there credence to that claim? And how would you respond to those who express fears about the so-called capture or the attempted capture of the judiciary?
Well, I've not heard anybody talk about the capture or attempted capture of the judiciary. I hope nobody even thinks there could be a ground for that. The judiciary has a very important role in protecting our democracy. The Constitution says before somebody who is appointed as a judge may begin his or her job as a judge, they must take an oath or make an affirmation and that they will uphold and protect the Constitution. We as members of the judiciary, we must know when we get appointed, that when we get appointed to the bench, we are not about popularity. I'm not supposed to give a judgment that I think will make me popular with whether it's a particular political party or the population in general or certain sectors of society. I must make a decision that, in my view, accords with the Constitution and the law. And if that might mean I won't be popular with certain people, or I will lose some friends, maybe in politics, who are in politics, or in the media, or wherever, that's just part of the job. And those who, if there are any judges who allow themselves or may allow themselves to be captured, they will be doing a disservice not just to the judiciary but to themselves, because when anybody, I mean, people might want you to make a decision along certain ways, along certain direction, but if you agree and you do that, they lose whatever respect they had for you. They'll never respect you. And we as judges are not wealthy people. We mostly just depend on our salaries, and what we have that we should guard jealously is the respect and the confidence that we enjoy with the public. And those people that influence you to give a judgment in a certain way in some matter, and you agree, they will never regard you as a proper judge. But if they know that they can't even raise that issue with you, they might not like you because they can't use you then, but they will respect you throughout. And we should always remember that if we do our job in accordance with our oath of office, and we know that our integrity is the only thing we have, then we know we'll enjoy respect throughout.
Just two last questions, Judge Zondo. One is a philosophical question around the concept of what is normally referred to as judicial activism. What are your thoughts around that concept? And the last question, pardon me if you have answered this question, you have appeared before this body many times, and that is the role of the judiciary in a developmental state. And if there are any judgments that you are able to refer us to where you have expressed your views around the role of the judiciary or what you have done as a judge in fulfilling that role of a developmental state. Thank you.
Well, as a judge or judicial officer, you have to operate within the parameters of the Constitution and the law. You may not do anything that the law doesn't allow you to do. You may not do anything that the Constitution doesn't allow you to do. But within the parameters of what the Constitution and the law allows you to do, in certain circumstances, there is a lot of room for you to, for example, give a certain kind of remedy that maybe another judge might not give because they do not have inside them the activist judge that that is inside you. So, and I think it depends on one's approach and philosophy in terms of the law. And I might not immediately be able to give you a judgment. I don't think there is a judgment where I've referred to a developmental state as such. But I think, for example, if you look at a lot of judgments on evictions, for example, you will see that in a number of those judgments, you can see the activism of some of the judges who wrote certain judgments. But they've done it within the parameters of the Constitution and the law.
Colleagues, I'm well aware of the hunger issues. May we finish with him and then break for lunch afterwards, please? We still have 3 more. May we? I know the good doctor was complaining about the hunger issues. Can we finish with him and then go for lunch afterwards?
I agree, Chief Justice, but there are 2 outstanding questions that were not answered.
Oh, yes, no, that, or you, should I add you for that? Or you, all right, okay. I'll look them up. Yes, Prof?
Good afternoon,
If you
Commissioner.
could put your mic on, please, Prof.
Eish. To ask a question at the end of the interview. Because many of
You are permitted to pass.
many of my questions have been asked, but just one. What is your view regarding the application of gender equality in a customary law context? One other thing, since if we are given this opportunity, it's just a comment on this one, we are still confronted by the demographics in relation to access to justice of the courts.
Well, there are already judgments that have dealt with the issue of gender equality in terms of customary law context, and they are the law, you know. So the Constitutional Court has given them. I think some high courts have given them as well. So it's very important as far as I'm concerned. With regard to access, the second question was about continuing to. I'm sorry. I think I forgot the second question.
The question is, in fact, it is a concern.
Yes.
Yes, about the historic demarcations
Yes.
in relation to access to justice.
Yes.
Where the High Court in Bishop, if you want to
Yes.
appeal, you'll go to Grahamstown in the Eastern Cape.
Yes.
You are all the way from Queenstown,
Yes.
passing Bishop High Court. When the next court to you, as an ordinary citizen in Bishop, but you go all the way up there.
Yes. No. That's a very important question and concern. Actually, one of the judges, President, I spoke to a few days ago, just to get a sense of certain things in the various high courts in preparation for this interview, we talked about that. And one of the things I said to him was this: I don't think that in relation to, for example, the jurisdiction of high courts, and that would apply to lower courts as well, I don't think that we should necessarily be married to the provincial boundaries. Because I was thinking, if this is the border between Mpumalanga and Gauteng, and going to the High Court in Gauteng is just an hour's drive, but going to Mpumalanga, I'm just making an example, is 3 hours. I don't see why it ought not to be possible to put in place legislation that can make sure that you can go to a court that is closest to you. We have, for many years, been used to certain boundaries, and we have taken it that that's how things are or should be. But I think that there might be a case for saying that should be explored. It's not something that I've had a debate with other people and see what I may be missing. But it seems to me in line with what the exchange between myself and Commissioner Fori in regard to the expert opinions, reports, the starting point should be, what is it that would best serve the people? Is it that somebody, just because they happen to be on this side of Mpumalanga, of the border of Mpumalanga, they must now travel 4 hours to get to the High Court when there is a High Court that is within an hour's drive? So it can't be. We've got to say, what do we want to achieve? And then use legislative instruments to get what we want.
Dr. Mutseka has written me a note saying that upon further reflection, there are 2 questions of his that you did not respond to.
I apologize.
And he says one of them is whether it is fair that 1913 should be set as the cutoff date in relation to land claims, and the other relates to whether, and I hope I remember it correctly, Doctor, it relates to whether it is fair, it is just to be where we are right now in terms of which land restitution or land when restituted does not get controlled by royalty, those who used to control it. But you can have a situation where a community property association is to the exclusion of the traditional leadership in control of that land. In other words, similar to the Bakataba Kafela case that we decided not so long ago. Yeah.
Yes. Well, with regard to the first question, I don't know if Dr. Mochecha assures me that there will be no matter that will come before us challenging that cutoff point of 1913. So, but I am one of those who were concerned when that cutoff point was made. But I haven't done research that would show me that that there aren't any problems that were sufficiently persuasive to justify it. I haven't done that research, and when you say something is fair or something is not fair, you have got to have all the information, and I'm reluctant to do that without that information. On the face of it, yes, but it may well be that when I'm exposed to all the considerations that are relevant to saying, do we make a cutoff point in 1913 or elsewhere? I might be persuaded that it's not unfair. But on the face of it, it does appear unfair. And then I would have thought that if land was when it was taken from people, it should be returned to the people that had it before. But I think that there are situations where we have had stories that, for example, Inkosi of a certain area and his, I won't say and her because most are men, and his council are not using the land for the benefit of the people, and they are reaping the benefits for themselves and a few people in the community. So I don't have the history of how property associations such as the one the Chief Justice is talking about that are used, how they came about, and whether it wasn't a way of saying, if we don't do it that way, most people won't see a cent from this land. So one would need quite a lot to look at it.
Minister?
Thank you and good day.
Good day, Minister.
Okay. I want to refer to the questionnaire for judges on your application. There's a question 6 there on the questionnaire for judges. So then which requires you to finish the chronological particulars of employment since leaving school or university. This is a question in relation to the follow-up on community service raised by one commissioner earlier. I see you have been at the Legal Resource Center as a fellow. Also,
yes.
Then also you have been a director for SS Mate and Zondo Incorporated for the period 1989 up to 1997. I want to check if you still recall how many pro bono matters have you done then? Secondly, you see, we are operating in a country where there is a national development plan of the country, the plan for the country. And then one of the pillars of the plan is that all South Africans must play their parts in contributing for a better South Africa. I'm raising it based on the sense that you've got challenges of access of justice in the country. Then as a legal practitioner, being a judge, is it not something that you've not considered to do to make sure that maybe you assist the poor of the poorest in the communities so that how do they make sure they access justice? But you've raised the issue of your schedule that you had to go to KZN once. But I believe there's a period where judges go on recess. Have you ever considered doing a community work during that period? There is recess. We understand you need to rest. On top of that, I believe you take leave as well. But the point that I'm trying to raise is with regard to community service to say, what is it that, or is something that you're envisaging to do when you retire? That's my first question to you.
Okay. Well, I don't, you know, when these days you speak about pro bono work, to me, it has the connotation of work that's formally regarded as pro bono work. But during my time and the time of many my age who were in practice, when I was in practice, if you were an African advocate or attorney, almost by definition, there would be a lot of work that you do for people, for clients, for which you are not paid. There would be a lot of it. And many of us saw our positions as attorneys and advocates before 94, definitely, as positions that we should use to try and help our people. So I think that there was a lot of work that you can properly call pro bono work that I did. Sometimes you charged, a very reduced fee, and sometimes you charged, and actually you'd end up saying, hey, those clients that you are doing this work for free, or those you don't charge, they are the ones, if you make the smallest mistake, who run to the Law Society to report you. You didn't do this, you didn't do that. Not the ones who pay you. So I've done a lot of work as an attorney, which was helping societies. Actually, you remind me that in 1986, I was, although I was still doing articles, but I was the de facto attorney for an organization that was called Sibongile Residents Township Association, residents, not ratepayers, for the township of Sibongile. They were being evicted by the township authorities at that time, and Mrs. Mklenge's office was instructed, and I was the one who did that file. I briefed the then advocate Pius Langa, and we went to the magistrate's court in Sibongile to deal with matters of evictions, and some of the residents were being charged with trespass. The accusation being that they were trespassing in their own houses because they had been told to leave the houses. We went there, and I remember, well, we lost, but the people were so happy with how we had fought for them that when we finished in court, they asked us to go to the chairperson's house, and they slaughtered for us, and they were very happy. So we took up issues that related to communities, and yeah.
Okay. Justice, on page 3 of your CV, item number 8, the Chief Justice has appointed you as the chair of the conference organizing committee.
Yes.
And then the question is, how will you ensure that you exercise prudent financial discipline in making sure that the conference takes place within the allocated budget of 7 million? Earlier in the meeting, we were told that there's a 7 million budget for that. So as a chair, given this responsibility by the Chief Justice, how will you make sure that there is exercise of prudent financial discipline?
Well, there is, we have a committee of judges. That committee, that's the one I chair, that committee is assisted, and I dare say ably assisted, by the Secretary General and her team. And her team includes financial people. And everything that is being done has to be within the budget. So they have to work within that budget, and I have no reason to think that they are not going to be able to stick within the budget.
Then on Annex RZ1 is the list of judgments that you've delivered. I think they start from page 1 up to page 9. That's the list of judgments that you've delivered. But I've got interest on the judgment that are on page 6, the list of judgments, Constitutional Court judgments
Yes.
from the period 2012 to 2016.
Yes.
I see you've managed to deliver 42 in 4 years. And then being the Deputy Chief Justice, should you be granted that opportunity, should we agree here, of the country? Given this experience and the record that you've done here, how will you ensure that you also build that capacity to your fellow colleagues in the judiciary who are normally confronted or challenged with regard to the delays in delivering judgment? I'm referring this also to the aspect that the Chief Justice raised earlier, the issue of mentoring. Also, that you address the issue that Advocate Masuku, not if not Musomi, raised with regard to you being a team player.
Minister, in the Constitutional Court, I don't think that there is anybody that requires any mentoring. But in regard to, for example, high courts, I think that it's very important that particularly newly appointed judges, that they be exposed to senior colleagues, helping them and mentoring them. And I think that the various judges president, play that role in regard to their courts, together with, I think, some of the senior judges in each division. So it's something that one can encourage, but I can't go to the High Court and start mentoring. Thank you.
Okay. Page 11 of your CV, paragraph 13. You have chaired as a chairman of a committee of heads of court that was established to consider various proposals on the usage of official languages in courts. And then it further, on page 12, reports that you have since submitted that report to the then Minister of Justice, that's Minister Mavanda, and it's your belief that the two reports could have by now contributed to search for a solution to the language problem in our courts. Given the time that has lapsed, I think it's almost 9 years since you submitted that report. I want to know your comment on that one. Also to say, you remember section 30 of the Constitution. If you go through it, there's a right to a language of choice. And there's the issue that maybe when you see also linking it with the capacity of our interpreters in courts, to say that then, what do you think needs to be done, given that there was a report that in your own belief you submitted it, then it was going to contribute to the search for a solution to the language program. Now we are 9 years later. What do you think needs to be done under the circumstances? Have you ever taken pains to check the progress, how maybe the ministry or the department has implemented the recommendations of your report?
Well, Minister, that what you are reading from is a document that reflects my involvement in various leadership structures. But it's it was obviously submitted a lot of years back. From a certain stage, and that is a number of years from now back, we in the committee, I think, accepted that there was a problem. And it's maybe not so much the minister, because even we as heads of courts could not reach agreement. But that, as far as I understand, as I said earlier on, seems to have been resolved, because a decision was taken, as I understand it, by the heads of courts to say the language of record in our courts is going to be English. So I lost that debate, Minister.
For your benefit, Minister. When we realized that the minister wasn't taking a decision, we took the decision.
Yes. Then let's go to paragraph 14. Paragraph 16, my apology, of your CV. It's women in leadership position in the judiciary. And then on page 14, on the top of it, it says, one of the challenges facing the collective leadership of the judiciary in this country is to take steps to have women judges appointed to leadership positions in the judiciary. What I'm purely doing is to enhance the comments that we make by fellow commissioner. But I also believe that you might have sight of the investigative report by the Commission for Gender Equality on the lack of gender transformation in the judiciary that was released in 2016, in which one of its recommendations, it's in particular a recommendation to the Judicial Services Commission that it needs to be engaged or encouraged to adopt a policy or criteria that will ensure that women, with particular preference, black women, to be appointed as full-time judges in order to address the current imbalances. Being the deputy, should you be afforded an opportunity, as we are doing now, to become the Deputy Chief Justice of the highest court in the country? How will you assist the Chief Justice to lead this process in order to realize the recommendations from the Commission on Gender Equality? That's my last one.
Well, as I said earlier on, one probably needs a multi-pronged approach. I did answer the question when it was asked by one of the commissioners. There needs to be a serious effort of making sure that women lawyers are given a lot of work, quality work, and not just, divorce matters and maintenance matters, quality work, commercial work, and so on. And as I said, we need our parastatals and government departments to really adopt the kind of approach that I said the trade union movement adopted in regard to me in the 80s. They did not say, if we allow Zondo to do this case, he's going to lose, and we don't want to lose. They said, we are giving him these cases. We believe he will do his best. We accept that he might lose some cases, but he will win some, and it's an investment. So parastatals and senior management and government departments must think about the long-term investment that is inherent in giving a lot of work to women practitioners. And of course, I think we also talked about special training sessions. I don't know if I expanded earlier on, but during Minister Mabandla's time, there was a time when funding was obtained, which was used for training, especially women lawyers. I understand that issues of funding are making it difficult to do that, but maybe people in the private sector should contribute to a legal transformation fund that should be established. That's what I suggested to the BLA a few years ago, where everybody who wants transformation in the legal field to be advanced can make contributions in terms of money, and those funds can be used, for example, where you can say, so and so and so and so must get involved in a certain case, and if the client won't pay, if the client agrees but doesn't have money, then that fund will pay them, but they get the experience. And all of us, I said to the PLA then, I was offering I wanted to be the first one to donate 10,000 rand if once they have established that fund. They have been unable, and I will increase it to 20 if they can get it up and running soon. Thank you.
Well, just to clear up something relating to your chairpersonship of the committee that is organizing the CCJA, I think it's crucial, particularly because we are friends. It may well be that I was profiling you for possible consideration, you know, as a nominee for the position Deputy Chief Justice. That's why you, of all people, are chairing that committee. By far, you are, in terms of legal judicial service, you are senior to all the judges in that committee. But how did it come about that you and not any of those colleagues is chairing that committee? What gave rise to that possibility?
This is what gave rise to it, Chief Justice. At some stage, I think the year before last or last year, I can't remember, I think the year before last, you were unable to attend a meeting of what is effectively, I think, an executive committee of the CCJA.
Executive Bureau.
The Executive Bureau in Gabon. And I received a call from you, and you said you had approached other colleagues who were senior to me to find out if they were available to go and represent you there in that meeting, and they had all be, those that were ahead of me were not available. So you asked me if I was available. I said yes. I went to that meeting and attended and represented you. I got a lot of information about the business of the CCJA and what was planned. And I think that when it came to the establishment of the committee, the fact that I had been part of that meeting was important for somebody who would then lead that committee. That's my recollection.
And the minister said something about recess being for resting. Would you like to comment on that?
Actually, thank you, Chief Justice. I had meant to say something about that. Minister and commissioners, recess for judges is not a holiday. My wife asks me sometimes why I come home to Durban for recess, because most of the time I'm busy working in my study. She asked me why I don't just stay in Joburg and work there. That's simply because although it is called a recess, it's got nothing to do with resting.
If you are serious about your responsibilities as a judge.
Yes, that's true. But also, Chief Justice, particularly for a court such as ours, you know, in the High Court where you sit most of the time alone, you might be able to finish certain judgments before the end of the term, so that when you go on recess, there are no reserve judgments. You might be able to say, no, these reserve judgments I'll do later. Let me use part of the recess as a holiday. Maybe you can do that. In our court, you have no chance of doing that.
Well, no, as a matter of principle, as a judge in the Labor Court, the Labor Appeal Court, Pretoria High Court, was recess ever intended to be resting period?
It was never intended. It's always intended as an opportunity for you to catch up with your work, do reserve judgments, do research, and so on.
Did you use it for resting as a High Court judge?
No.
Having finished some cases?
No.
Commissioner Norman?
Good
Mike,
good
please.
afternoon.
Thank you. Thank you, Chief Justice. Good afternoon, Justice Zondo.
Good afternoon, Commissioner.
Thank you. My question really relates to the Florence judgment.
Today?
The Florence judgment.
Yes, yes.
I just want to understand, because in that judgment, you did not want to upset the decision of the Land Claims Court having calculated compensation that was to be paid as equitable redress to the claimants. Now, what I want to understand, it was simply a mathematical calculation that you've got the 1,350, which was the purchase price, and you escalate it by CPI, and then you get about 1.4 million. When you look at that calculation and you compare it with what gets paid to the landowners when they are compensated for restoring the land to the claimants, that differs in my view, because here the calculation doesn't take into account, for example, as to the extent of the land that was lost. It doesn't take into account how many cattle the family had. It doesn't take into account the inconvenience, except that, of course, Solatium was paid. But it doesn't take into account all those considerations that I believe perhaps should form part of the computation of the entire amount that is supposed to be paid as equitable redress.
My judgment in Florence didn't deal with that. My judgment dealt with the cross appeal. And the cross appeal related to the question whether the family or the claimants were entitled to an amount that they would use to put up a memorial plaque. That's what it was concerned about, my judgment. And I concluded, after looking at various provisions of the statute, that actually once the Restitution Act, once you have received what falls within the ambit of, I think restitution, I forget the terminology now, but once you have received what they had received, they were not entitled to anything else, including any money relating to the plaque. The process of arriving at that conclusion, as you may have seen, goes through examining a number of provisions. Other colleagues wrote about the appeal. I didn't write about the appeal, but they wrote about the appeal.
Yes, thank you. But now, having had my comment on it, would you believe that that computation is still something that should be done in simply applying the CPI onto the purchase price?
Well, my difficulty, Commissioner Norman, is that when it comes to judgments written by colleagues, yes, even if I've agreed, yes, to recall everything and be able to comment, one would need to refresh one's memory. And as you have seen, even my own judgments, out of the 148 or so judgments reported judgments that I've written, I can't remember all of them, just like, unless it's a recent one, or I'm alerted to saying, well, what about this, blah, blah, blah.
Thank you. Thank you, Chief Justice.
Thank you, Commissioner. If you could switch off the mic, please.
Oh,
Before Commissioner Masuku, who is the last, colleagues, should we then break for lunch, or should we finish everything and then break for lunch? Think about it. We'll wrap it up after Commissioner Masuku.
Thank you, Chief Justice. Good afternoon.
Good afternoon, Commissioner.
Justice Zondo. The
The question I have relates to your view of judicial independence. And the question is whether you consider that there are threats to judicial independence, and if you do, and you can identify those threats, what your appointment as a Deputy Chief Justice does to increase the potency of the judiciary to forestall any threats to judicial independence. The second one, which is also a short one, do you agree that the Supreme Court of Appeal should become the final court of arbiter on constitutional issues in circumstances where the Constitutional Court judges or the Constitutional Court, the Constitutional Court judges suffer from a conflict, the nature of which they are unable to deal with that matter? And I know it's a matter that I was involved in, where I appeared before, and you're very kind to me, I must say, when I did appear for the first time in the Concord. So that's the question. There may well be different cases which render the Constitutional Court judges unavailable to deal with the matter. But we know what the law is in as far as jurisdictions of the Constitutional Court and Supreme Court of Appeal is concerned. Would you agree that there is an anomaly where a judgment of the Supreme Court of Appeal becomes a final court on a matter of constitutional significance?
Thank you. Let me start with the last one. You would, of course, be aware that I was party to the judgment that was delivered pursuant to your appearance in the matter that you are referring to. And I have been party to another judgment since then, which went along the same lines. So I agree that it is rather an anomaly, if you want to call it that in certain circumstances, a court lower than the highest court can end up being final. But I think that it's practical exigencies that dictate that situation. That's how I see it. And it seems to me that it seems to be now the law. As I say, it might be that it's not a satisfactory way. Maybe on another occasion, somebody will come before the Constitutional Court and argue that though we should take a different approach to the one that has been taken in those two matters. With regard to judicial independence and my appointment, if I'm appointed, whether as Deputy Chief Justice, what my role will be and whether there are any threats to judicial independence. As we speak right now, I am not aware of any threats to judicial independence. That's the first point. The second point is this. We take our independence as judges very, very seriously. It's critical for our democracy. We dare not take chances with regard to that. And its maintenance doesn't depend on us as judges only. It depends also on the populace, the citizenry, how much they are prepared to fight for judicial independence to be maintained. But talking about myself, anybody who took trouble to look at my record in terms of judgments I've given, I would be very surprised if anybody had that opportunity to look carefully, were to ever think that we are here dealing with somebody who is not independent-minded, who might compromise judicial independence. I could go on and on in terms of practical examples which have shown my independent-mindedness. So if I'm appointed as Deputy Chief Justice, I will play a very important role to make sure that our independence, the independence of the judiciary is not compromised. Thank you.
Thank you, Chief Justice.
Thank you. That was the last commissioner. Thank you very much, Justice Zondo. I was hoping on a lighter note that you'll come somewhere closer to my 2 days interview, but you have failed.
I failed dismally,
You
Chief
failed
Justice.
dismally.
But I'm not complaining.
Thank you. You are excused.
Thank you, Chief Justice. Thank you, honorable commissioners. I appreciate the opportunity you have given me. And quite frankly, nobody, gave me a hard time, as the Chief Justice mentioned. I think everybody asked questions very, very legitimately and very, very professionally. I appreciate the opportunity. Thank you very much.
Thank you, Justice. Colleagues, are we going to round up or are we going to eat?
My colleague is very hungry here.
All right, okay. Now, for how long? 30 or 45 minutes? Can we agree to 30? The majority says it is realistic. Then let's finish so that we can have 1 hour.
Long hour, yes.
Can we finish? Please. Thank you. Please, good people, clear the room. We're going to finish.